Today we are here for State v. Dawson. Before we begin, are there any pretrial matters?
Yes, Your Honor, the defense does have pretrial matters today. Please, you don't.
Okay, just a second, Chief.
Grady Loman for the prosecution. We also have a few pretrial matters.
Okay, go ahead, Ms. Chief.
Yes, Your Honor. First, I'm here to public review, which contains all possible exhibits for this case, all relevant case law, the Midlands Penal Code, and also the rules of evidence for the minutes.
Do you have a copy for the bench?
Yes, with the commission, I will present. Your Honor, we'd also like to tender into evidence the special instructions for this case, the stipulations for this case, and also the orders for the order of motion and
Mr. Loman, you're good with all the stipulations?
Yes, Your Honor, we have agreed to all the stipulations.
permission. Also, Your Honor, we'd like to know your preference of movement about the well, of permission, asking permission to approach opposing counsel, the witness, and the bench.
Feel free for the attorneys to move about the well. Don't worry about asking permission to approach opposing counsel, but do ask permission to approach a witness. And when sure they're being conscious of their space.
And last, Your Honor, we would like to invoke Rule 615 of sequestration of the witnesses in this case, except for a party representative, ours doing the
Okay, all the witnesses that are going to testify are constructively sequestered from the courtroom. Mr. Loman?
Yes, Your Honor, before we go into pretrial matters, may we make introductions for the court? My name is Grady Loman, as you know, and I, along with my co-counsel, Ms. Shelby Smith and Ms. Rachel Leggett, represent the people of Midlands in today's case. Your Honor, before we begin, we would like to ask your preference as whether or not to consider our objections outside the hearing of the jury because of the constructive nature of the trial, or should we ask for a sidebar?
No, once an objection is made, we'll just pretend that we're in sidewalk.
Yes, Your Honor. Opposing counsel also provided a copy of the order on a motion in limine in this case. Specifically, one of the issues addressed is the defendant's motion to exclude character evidence. As you know, the Honorable Judge Wayne has decided on behalf of this court that all rulings on character evidence are reserved until they come up at trial. However, Judge Wayne has noted that in Midlands, since there are no rebuttal witnesses, the prosecution may offer preemptory rebuttal evidence for character traits under 404.
All right, do you have a copy of that for the court?
I do, Your Honor. I also have a copy of notice of intent to offer character evidence in accordance with Judge Wayne's ruling. May I approach?
All right, so we will deal with character evidence as it becomes relevant.
With that, Your Honor, the prosecution is ready to proceed.
Defense may proceed as well.
All right, well, let's begin with opening statements.
Your Honor, before we begin with opening statements from Ms. Shelby Smith, may we ask permission to set up the courtroom for use of visual aid?
Yeah, and throughout the trial, if an attorney's going to use a demonstrative, just feel free to go about doing that.
May I proceed?
You may.
We all make decisions. Right, wrong, grave, or innocent. And the decisions that we make not only affect us, but those that are around us. And when we add up these decisions, they will define who we are. Ladies and gentlemen of the court, my name is Shelby Lee Smith, and today I represent the people of the state of Midlands. Today we are here because of the decisions that were made on September 24th, 2010. We are here today because of the decisions that were made on Vanessa Sullivan's 21st birthday. But before we begin, I would like to tell you a little bit about Vanessa. When she was in high school, Vanessa made a great decision. She decided that she wanted to attend Calkins College. And then, in early 2010, Vanessa decided that she wanted to be a lawyer, just like her mom. And then on September 24th, she made the perfectly innocent decision of deciding to celebrate her birthday with her best friend. It is also on this day that she asked Danny Dawson, the defendant, to be the designated driver. We are here because of the decisions the defendant made the night that he said he would be the designated driver. On September 24th, 2010, the defendant, Danny Dawson, arrived at Chuggy's Sports Bar at 2 p.m. with Vanessa Sullivan and best friend Taylor Hobson joining him at 7 p.m. He was reminded several times that he would be the designated driver, and yet the defendant decided to drink. As the party began to leave the restaurant, the defendant stumbled into the parking lot, and right there, ladies and gentlemen, was a cab. Right there, one right decision, one moment of thoughtfulness could have turned this entire night around. But the defendant decided to drive. And not only did he decide to drive, he decided to take a back road in the pouring rain with no lights. Ladies and gentlemen, the defendant began swerving. Vanessa Sullivan pleaded for him to stop. Taylor Hobson begged, "Danny, please, slow down." Once again, Vanessa Sullivan pleaded, "Danny, do not risk it." The defendant continued to swerve. Why were these two young ladies so upset? Because they were going into a part of Canyon Road called the Death Zone. Ladies and gentlemen, the Death Zone is where the road narrows, the guardrails stop, and there is no light to break the night. The defendant had a very important decision to make. Today you will hear he did not slow down. He did not heed the warnings of Vanessa or Taylor. He told them to shut up. He turned up the music. He made his decision. And moments later, Vanessa Sullivan was dead. Ladies and gentlemen of the court, as the prosecution in today's case, we bring for you the burden of proving that Danny Dawson is guilty of not only driving under the influence, but also of murder. In proving our burden beyond any reasonable doubt, we ask that today you take these three questions into consideration. 1, did the defendant's actions create a reasonably foreseeable risk of harm? 2, did the defendant disregard the risk? And 3, did the defendant's recklessness create a serious risk of death to Vanessa Sullivan? In order to answer these three questions, we will also be calling 3 witnesses. The first, London Bennett, resident of Canyon Road and witness the night of the wreck. Ms. Bennett will explain to you the motions of the car just before the wreck and the actions of Danny Dawson, the defendant, just after. Second, we will call Ms. Taylor Hobson, best friend of Vanessa Sullivan and backseat passenger on the night of her murder. Ms. Hobson will tell you the decisions the defendant made on the night of September 24th. Listen closely as she tells you about the car ride she wishes she could forget and about the last fleeting moments spent with her best friend. And finally, you will hear from Officer Ryan Foster, the first responding officer on the scene and the officer who administered the field sobriety test to Danny Dawson. Officer Foster will also tell you about the investigation that he personally led to find what exactly caused the wreck that ended Vanessa Sullivan's life. The evidence and these 3 witnesses will show that Danny Dawson did knowingly and willingly drive under the influence of alcohol and commit murder. And that is why, at the end of today's trial, we will ask that you find the defendant guilty of murder. We ask that you will make the right decision and the just decision, as my co-counsel, Grady Loman, asks you to find the defendant guilty. Thank you.
Does the defense have an opening statement?
Yes. May I proceed?
The government just told you about a mistake. Danny Dawson did make a mistake. But a mistake does not equal murder. Ladies and gentlemen, my name is Jani Patel, along with my co-counsel, Kimberly Jeter and Artem Jokov, represent Danny Dawson. This is Danny Dawson, a student at Calkins College, aspiring to be an attorney one day. On September 24th, 2010, Danny Dawson went to celebrate a friend's birthday. Later that night, he met up with that friend, Vanessa Sullivan, and her friend, Taylor Hobson. They met at Chuggy's Sports Bar. The three of them enjoyed a few drinks and listened to the favorite band, Chatterbox. As the night began to wrap up and the three of them began to head out of the bar, evidence will show that Danny Dawson made conversation with two people before he left that bar. If you could please listen carefully to my next statement. Jordan James, the bartender at Chuggy's, and Sam Lyons, the cab driver, both made conversation with Danny Dawson before he left that bar. And neither of these two people believed that Danny Dawson was intoxicated. As the three of them got into Vanessa Sullivan's car and began to drive towards her house, the weather was absolutely terrible that night. It was a driving rainstorm. And to make things even worse, the road they were on was a curvy, unlit, two-lane road that had seen numerous prior accidents. You will learn that Danny Dawson tried to avoid an object that suddenly appeared on the road he was driving on. As he tried to avoid this object, he lost control of his car and it swerved off the right-hand side of the road. As he tried to regain control of his car, the car overcorrected and it swerved off the left-hand side of the road, hitting a tree. Unfortunately, Vanessa Sullivan did not make it through this accident. Danny Dawson made a mistake, but a mistake does not equal murder. Danny Dawson was not the only one that made a mistake that night. The government as well made a mistake. The government decided to charge Danny Dawson with murder without even investigating the case. You will learn they did this because Vanessa Sullivan is the daughter of Midland's district attorney. Ladies and gentlemen, as a defense, we have no burden. It is not our responsibility to prove anything, but we will call three witnesses to show you what happened that night. The first witness, Jordan James, is a bartender at Chuggy's. She will tell you about Danny Dawson's previous responsible actions. Jordan James had made conversation with Danny Dawson just before he left the bar. And she will tell you that Danny Dawson did not seem to be intoxicated when he left that bar. The second witness we will call, Sam Lyons, is a cab driver. He also made conversation with Danny Dawson. However, his conversation took place in the parking lot just before Danny Dawson got into the vehicle. And please listen carefully to the next statement. Sam Lyons did not believe that Danny Dawson was intoxicated when he got behind that vehicle. The third witness we will call, Mrs. Leslie Roman, is a professional in accident reconstruction. She will tell you that Danny's actions while driving coincide with one other driver who is trying to avoid an obstacle on the road, and then also trying to regain control of his vehicle. Mrs. Leslie Roman will tell you that Danny Dawson made a mistake. But a mistake does not equal murder. Ladies and gentlemen, it is the prosecution's burden to prove each and every element of this case beyond all reasonable doubt. However, they will not meet this burden. Members of the jury, today's trial is about a tragedy that Danny Dawson will have to live with for the rest of his life. Danny Dawson lost a good friend in that accident. That is why at the end of this trial, I will ask my co-counsel, Kimberly Jeter, to come before you and please find Danny Dawson not guilty. Danny Dawson did make a mistake, but a mistake does not equal murder. Thank you.
Very good. Give us a second.
All right, I'm ready, and I'll start so that we can get this show rolling. With the prosecution opening, I'm not gonna make any comments. It was excellent. There were a few, content changes, but they won't benefit everybody, so I'll get with you directly on those. All right, with the defense opening, again, it was excellent. And I'm about to make a bunch of comments, so don't think that I'm, criticizing what you did. These are comments that everybody can learn from, and you obviously don't know because you've never been to competition. Courts are real formal, and they have some really odd rules that make no sense. All right, so from the beginning.
That's an understatement.
Treat the judge like, super, super formal. Don't ever say yes or no. It's always yes, Your Honor, or yes, sir, or something, formal. I don't know why, but never walk through the middle of the counsel table. Always walk around. The first thing any attorney needs to do after an opening or after a direct or a cross is take down the other side's demonstrative. All right, don't leave it up so that it's a distraction while you're up there. Kimberly, Artem, and Danny, when you're introduced in opening statements, just to show respect to the court, stand up. There were a couple of times when you said, pay particular attention to this next statement. Anything that an attorney says during an opening is not testimony, all right? So you don't want the jury to pay attention to your next statement. What you need to say is, pay attention when the witness says X. Pay particular attention as Sam tells you X. Not me. And then at the very end, this is a little one, but you're not going to ask Kimberly to come forward. You're just going to say at the end, and that's why at the end, my co-counsel Kimberly Jeter will come before you and ask that you find them. But, all right, so those are all minor nitpicking things, and the fact that we're at that point in week one is awesome.
Yeah. All minor nitpicky as well. I do have one in pre-trial, and it's more of a general comment than it is technically for the pre-trial. Don't ever say you'd like to do something. I'd like to approach and give you this, Your Honor. Say, may I tender a copy of the stipulation to the bench, or something to that effect. And you're not entering stipulations in the record this time unless, or were you trying to enter all of them into evidence? Because you got to read them to the jury. Okay. Prosecution opening statement. I want to say just a quick thing about the themes. The themes are good. I think y'all did them very well. I think both of them could be very easily flipped. But we'll keep working on that. Prosecution opening shall be technically very proficient. I would say try and move around a little bit. You stood kind of in one spot until you went over to the demonstrative with actually have a comment about the demonstrative and kind of more technical suggestions as far as that demonstrative goes, but we'll save that for later. I'd say reduce the language in that if you can, but you need to move a little bit more. I have a lot of the same stuff that Deese had. Need to get the reason in why this is murder and not DUI. And maybe you said it and I missed it, but we've got to at the very beginning say why this is a murder case and not DUI. Because of his recklessness, because of the extreme indifference he showed to the value of human life, all of the decisions he made that led to the death of Vanessa Sullivan, all the turning points where he took the wrong path. That's what makes this murder and not just a DUI. We've got to get that out at some point. Defense opening statement. Okay, Deese already said this. Take down use demonstrative. Don't just leave it up. You might, if you can use it somehow, that might be good, but don't just leave it up. I had a suggestion. I think mistake does not equal murder. I think we said something slightly differently when we met a little bit before, but I think that's going to be really, really flipped on you. Maybe an unintentional mistake doesn't, or every tragedy doesn't equal murder, something to that effect. Beyond what Dee said, I have, you're spending too much time on your witness roadmap. Just one sentence witness roadmap. Put the majority of it in your story. And that is, That's kind of a general comment as well. You want to draw the jury into that story and that roadmap. In my opinion, I don't know what y'all's opinion on it is. My opinion is just for the judges who like to have that kind of thing. And I want to have the story. I want the jury drawn into your story, enraptured by your story by the end of the opening statement. All right, that's all I have.
I've got two quick things. First of all, both of those were simply fabulous. Probably the best opening statements I've seen on opening day ever in all the years I've done this. So great job, both of you. Just to kind of dovetail on what he said about the demonstrative, one way we can kind of talk about this when we work individually is one way to maybe use it, just kind of cheap gimmick, but you say, now the prosecution or the government came before you and this is what they showed you that they have to prove. As the defense, then you take it down or do something. We don't have to prove anything. Something like that, we can work on it. Secondly, both of you kind of stayed probably at a level 6 or 7 the whole time. If you vary your tone a little bit more, put more peaks and valleys in there, that always helps, which we'll work individually on as well. But something to just kind of start thinking about now. It's just a stylistic thing. But everything else I had down here has already been said, so we're good.
And the only thing going forward for the rest of this trial that you guys can try to take, Nathan maybe don't feel, in your objection arguments, never say, I think, or I feel, or I believe. It is always, this is not relevant because, or this is hearsay because. Right? Now, does prosecution have a case to present today?
Yes, Your Honor. I have permission to remove the visual aid.
Don't worry about asking for permission on the demonstration. Who's your first witness?
Prosecution calls on Ms. Bennett.
Okay. Mr. Bennett, Ms. Bennett?